Good afternoon, and thank you for joining the call regarding the Mountain Oaks Homeowners Association Act. Today, I will review a presentation with slides that address the many issues related to the Georgia Property Association Act that owners wanted more information on. And so I will go through the slides, and there are additional responses on the website under the frequently asked questions regarding the Act, and this presentation gives you an overview of currently of the status of the Homeowners Association versus that of converting to a Georgia Property Owners Association. The Homeowners Association that we currently are bound to, our community has declaration of covenants, conditions, and restrictions for Mountain Oaks. As any homeowners association, these documents provide for us the tenets of what the rules are in terms of the community and what all residents must abide by in terms of living in the community. And the documents are something that all residents should become familiar with and have access to them if you ever have any questions regarding the rules of the association. Every person who is a record owner or fee owner within the association has complied by way of purchasing property in the community that they will abide by the rules of the association, and by which there is an annual assessment fee that each owner is responsible for each year. And our association fee is $450 annually. The board of directors are volunteers, and they are elected annually or biannually by the community who they want to serve as their representation. And once that's done, the 7 board directors then identify and vote on who will be the president, vice president, secretary, treasurer, and member at large. No board director is paid for their services, and these are all volunteer offices. Assessments are again for the purpose of taking care of all of the common areas, the pool, the tennis court, and so it's very important that owners pay their assessments in full and on time. And that assessment covers the expenses, and as we go through the slides, you'll see why it's so important for us to be able to have the tools to address owners who are not compliant in paying their assessments on time or in full. The creation of a lien and personal obligation for assessments. Our documents in Article 4, Section 2 provides that the association may assess an annual assessment, and we do, and that's $450 a year, and that special assessments can also be assessed in order to take care of a matter that is not covered in the budget. For example, if there is a major repair that must take place with the pool, and that's something that was not foreseen, then the board of directors managing the association at that time may deem it necessary to assess a special assessment, and that would be equal across all owners, and that again is covered in Section 4, Article 4, Section 2. In addition to special assessments, there are fines that are associated when owners are not in compliance with covenant rules, and that fine is accrued by any owner who does not remedy an issue regarding a violation. Fines can average anywhere from $25 a day to a flat fine, for example, of removing a tree without association approval, and on top of that, an additional $25 a day. The Mountain Oaks homeowner delinquencies, and this dates back to January of this year, but as of January of 2016, there were 323 owners' accounts that had balances that were delinquent. That totaled an amount of $612,900. $915.99 amount owed in dollars to the association for delinquent accounts. The oldest account with the largest balance dates back to 1999, and that balance as of January was $30,634. And all of these dollar amounts include attorney fees and fines and going after owners to collect on delinquencies and assessments. $103,000 is owed by owners no longer living in Mountain Oaks. And so there are always attempts to collect on monies owed even if an owner no longer lives in the community. Since January of 2016, there's approximately $25,644 owed or paid in attorney fees. That's what we paid as an association to the attorney for legal fees to collect on assessments. So our legal fees can be pretty expensive depending on where the status of a owner's account is. Year to date, we've collected, and again, this goes back to March of this year. Year to date, we had collected $25,827.91 in collections, and you can see that that's basically a wash from attorney fees that were paid in January. And annually, thousands of dollars in assessments are written off annually because of statutory law requiring a write-off of uncollected assessments and fees that are 4 years old. So it's very important that we work as an association, the board of directors, to collect monies owed, when owed, and to be aggressive to collect them in a timely manner so that we are not accruing excessive attorney fees to collect and garnish and to go to court to win judgments on the collection of delinquent accounts. The general provisions and covenants of the bylaws, the MOA, Mountain Oaks Homeowners Association governing documents, specify actions that we can take that regarding delinquent owners. That includes assessing fines, fees, interest, and attorney's costs, filing liens on properties for assessment, fees, and interest and attorney costs, suing owners to collect on delinquent accounts, and foreclosing on liens held on properties. Currently, our documents provide for these action steps that we can take to collect on delinquent accounts. Article 5, Section 2, Maintenance and Covenants of Common Property to the Association. This basically just identifies for owners that it's our responsibility to maintain our lot and all the structures sitting on our lot, the parking area, and other improvements to our home. So a lot of violations that occur are external violations when owners don't take care, for example, broken garage doors, driveways that are cracked and really need repair, not maintaining their lawn. This section of our documents reminds us as owners that it's solely our responsibility to take care of the maintenance and repair issues regarding our property's external look. The following are some pictures of homes that would be in violation in our community, and these are not homes that are actually in our community, but there are some homes that are in our community that resemble some of these pictures in terms of the challenges. And so it's obvious that this home would need to be cleaned up from the outside because all of these items that are outside would be in violation of our documents, our bylaws, and governing rules. It's a picture of a sidewalk that needs repair, and again, owners would be violated and fined for not taking care of a driveway that had this type of an issue. Blinds, we hear a lot at board meetings about blinds. You can see from the street of some homes where blinds are broken and not taken care of. Trash being taken out in advance too early before the trash collectors pick up, or leaving the trash out even longer. And this is a code county violation, as well as our covenants require that we take our trash out at a specific time and bring it back in by a specific time, the actual trash barrel, so that cuts down on animals and rodents getting into the trash. Article 5, Section 2, again, addresses the responsibility of the owner and the action steps that an owner must take in order to address a violation. and what the association can do when an owner does not comply with the rules. And owners have 10 days from the receipt and notice of a violation to repair it and or to notify our property manager that they need more time. And for the most part, the association and our property manager will work with homeowners when that communication takes place. And so it really is the responsibility of homeowners to comply and make sure that they are being informed and notifying the association of need for more time. The association has the ability to execute self-help. It is not done in our association, and there's a slide that talks about why we don't do it, but our documents allows for the association to give adequate notice that the association will execute self-help. An example would be somebody not cutting their lawn and the association hiring a lawn company to cut the lawn, and the homeowner would be billed the cost of having the lawn taken care of. Again, that's something that has not been done in all the years that I have lived in the association, and I'm not aware of it ever happening in Mountain Oaks because of the cost. And here's another example of external work that needs to be done. That's not a color that's approved in our association, but it's just an example of taking care of your home, maintenance on your home. It could be an example of self-help where a home really needed to be painted and the owner, for whatever reason, is unable to or won't. Self-help could be executed. This is not the best example of that because our association would just not paint somebody's home, and the next slide will talk about why. Should the association repair or replace? It's cost prohibitive. There's no guarantee the owner will maintain repairs. The association may not recover full cost of repairs, and it's likely to lead to increase in annual assessments. And so self-help and repair just doesn't happen because of all of these reasons. You might fix the blinds, but you might be right back in the same place in another month or two. What is the Georgia Property Owners Association Act? Basically, it gives balance to the association and the tools when going into court to be able to argue a case with your attorney that an owner is in violation and to seek full remedy for the owner not complying and taking care of any issues. This is law, and the difference between the POAA and the current Homeowners Association that we're under, the HOA, is that we don't have statutory law that supports our governing documents and the rules. So although it's documented in there that we can foreclose, we actually don't have statutory law that supports our ability to do that under an HOA, but we do under a POAA. The board has the authority to manage the community, and there's been a lot of questions about a POAA giving the board more authority. And so I just want to go through the examples, the HOA versus the POAA under authority. The currently board meetings, a quorum must be present. POAA says that unless the docs specify a larger percentage, the quorum is half of the board. So we have 7. We need to have 4 people in place in order to have a majority present for board meetings. I'm sorry, let me back up. We have 5 board members, and we need to have a majority present at a meeting in order for us to vote. And so we need 3 board members participating in order to have a quorum. Act of the board by majority of the director presents a quorum which is present. And so there's no change in the structure from an HOA to a POA when it comes to authority regarding quorums. Homeowner meetings, a quorum. A POAA says that unless the docs provide otherwise, the quorum is 1/3 of the votes, and that's eligible voters. The Mountain Oaks bylaws currently provide for 25% of the owners of lots to which eligible votes appertain. Thus, there is no change. So again, no change in a quorum under the POA versus the HOA. Act of owners by a majority of votes cast, assuming a quorum is present, pursuant to the Nonprofit Corporation Code, except amendments to the declaration going forward, shall require agreement of all lot owners to which 2/3 of the votes in the association appertain. Thus, approving further amendment goes from a majority to 2/3. So there is a change there. For example, looking at changing our governing documents, right now under the HOA, we need half. Under a POAA, we would need 2/3 vote. And here are some frequently asked questions that have come up as we have presented the POAA to owners at monthly meetings, as well as on a webinar that we did back in March. And these are some questions that have come up over time that we thought we would address in this presentation. Doesn't our HOA governing documents already allow for placing liens and foreclosures on seriously delinquent assessments? And I talked about this earlier. Yes, it does, but a lien must be filed with the court, and as such, court costs and attorney costs are incurred. Under a POAA, it establishes an automatic statutory lien for unpaid assessments and other charges. This means that our attorney, there's no legal documentation that needs to be submitted to the court because it's automatically established under the POAA. So we have an owner that owes money, they want to sell their home, we are now a POAA. Everybody that is involved in the selling and the processing of that sale understand that they've got to do the background checks, they've got to do the lien checks to ensure that there are no liens on the property, because those liens would then transfer to the new owner under the POAA. Both the seller and the buyer would be liable legally and responsible for any liens. And so it's an incentive to ensure that there are no liens and to do all that, the dotting of the I's and crossing of the T's. Georgia law does not allow HOAs to foreclose under the existing provision, even though it's within our documents. And so you need a POAA to actually do this, to do a foreclosure. Does Mountain Oaks governing documents hold tenants responsible for following the governing rules? No, our current documents are all about, and the rules are all about the owners being in compliance and the owners holding their tenants in compliance. Under the POA structure, owner and tenants can be equally held accountable for delinquent assessments in violation of the rules. For example, we've got tenant in a home and we know that there are tenants, a letter of violation would go to the owner and the tenant, and fees would be assessed to both. And we could also go to court if a tenant has accrued fees and fines. We could go to court and hold the tenant accountable, and by way of that, we could get a judgment where the tenant's rent is being paid directly to the association and no longer going to the owner of the property until the account is remedied and paid in full. So that's a benefit, that under a POA we can actually hold tenants accountable legally and financially. Why do owners need the Georgia POA statutory law to enforce governing documents and rules? The POAA statute provides state law to address owner noncompliance and allows the association in appropriate cases to collect on these accounts. And again, because of statutory law, we have the law that our attorneys could use to gain a judgment on owners. Otherwise, it would be it's challenging for some cases to get a straightforward ruling from the courts because there is no statutory law. It strengthens the ability of the association to enforce the covenants and the rules and regulations. So the POAA, for the most part, as the board presents this, and our belief is that it helps us, it's a tool to help us protect our property values by holding all owners accountable for their properties. And it allows us to better enforce the rules because we have statutory law that provides and supports our ability to get judgment and to hold owners accountable when we have to take them to court. For additional information on the POAA, please contact our property manager, Aaron Byers, at Community Management Association, as well as the Mountain Oaks website. There's additional information there, and you may contact any board member for any additional questions you may have regarding the POAA. And that concludes this presentation. And again, we thank you for joining, and a recording of this presentation will be on our website as well as the CMA website. Thank you and have a great day.